I want to talk about a big mistake I see a lot of people unintentionally make, obviously, with regard to LLCs or limited liability companies and how it pertains to estate planning. So I'm Jason Neufeld. I'm with a law firm called Elder Needs Law. We are an elder law firm who specializes in Medicaid planning, estate planning, and probate administration throughout the state of Florida. And we often see LLCs with our clients. We don't represent businesses, but we represent individuals who often will have, for example, it's typically a rental property, an investment property, and they'll put it into an LLC. And they'll feel really good about putting it into an LLC because an LLC is supposed to provide asset protection. This results, and if they just put it in an LLC and don't take any affirmative action, they don't go through the corporate formalities, what's happening is it's giving them a false sense of security. An LLC, there are lots of ways to what they call pierce the corporate veil. There are lots of ways to not have the LLC get around the asset protection quality. And one of the biggest ways we see is by clients not having an operating agreement. An operating agreement is the instruction manual for who's in charge of the LLC, who makes decisions on behalf of the LLC, who has to vote and when, and people don't understand how important this document is to really formalizing the LLC structure. The other big issue is what happens after the owner or owners of an LLC pass away. Well, if there isn't an operating agreement, you're essentially inviting a probate because an LLC is not the individual. The LLC has typically its own tax ID number. The LLC is a separate living entity beyond that can outlive the individual who created the LLC. So the individual who created the LLC passes away and we don't have an operating agreement the operating agreement says what happens, and not only while the members or the directors are alive, but it says what happens, it's supposed to say what happens if any of the members pass away. And if any of the members pass away, this is one of the main ways in which we want to avoid probate. Now you can assign LLC membership interest to a revocable trust, which is fine, but the LLC, why have an LLC if you're not going to have an operating agreement? You want that asset protection, and that is one important component to achieving that asset protection. And while you're in the business of doing things the right way, the operating agreement can also dictate what happens to the asset after the initial members, or the owners of the LLC are called members. After the members pass away, the operating agreement can provide for that information. So if you have an LLC that's just kind of empty and all you do is you file something with the state every year, you don't have an operating agreement, you may want to give us a call, or an attorney who's experienced in this, a call, to make sure that you have that operating agreement in place to protect you while you're alive and to protect your heirs from not having to go to probate court to deal with the assets owned by the LLC after you pass away. If you found this interesting, please give it a thumbs up. Please give it a share. Please subscribe to the channel. Help me get good information out to Floridians everywhere. Thank you very much.